Welcome, everyone. Thank you to another one of our roundtable series with the Mika Center for Immigrant Rights' Immigration Impact Lab. This is our immigration litigation roundtable we have every few months, and today we're going to be speaking about eroding gender and family-based protections with our speakers and presenters, Peter Alfredson, senior attorney in the lab, and our special guest speaker, Ann Peterson, Senior Counsel from the Center for Gender and Refugee Studies. Thank you both for being here and preparing for this. Really appreciate it. I will go ahead and introduce, but just want to name, I know this is a issue affecting so many of our clients, of people that we care about. It's amazing to see even before starting, we have over 100 people in the room, which is, I think, the first time that's happened before the hour started. So thank you everyone for showing up. Please do change your name in the chat, since I think a lot of folks use the registration link my colleague sent out. That way we can know who you are. A little bit about Amika Center for those of you who are new to our work. We are a nonprofit focused on representing and defending immigrants, adults, and children who are at risk of detention and deportation. We are based in DC and Baltimore, and our impact litigation team does cases around the country, but mostly in the East Coast and Southeast areas. We focus on defending one another. You might have noticed by our former name, Care Coalition, we changed our name last summer to expand reflect the more national scope of our work. And we engage in legal defense and strategic litigation. The lab team is our smallest team, and we bring everything from class actions and large national lawsuits to individual appeals at the circuit courts and individual habeas petitions. And we have these roundtables so that we can connect and learn from, strategize with all of you, and not be in a vacuum, and be able to share strategies together as a movement on different emerging issues. A lot of our work is individual-based impact litigation for cases starting at the immigration court and going up on appeal and creating new precedent. But we also work on larger actions starting in district court increasingly. With that being said, I will pass over to Peter to get us started.
Thanks so much, Adina. It's so great to see so many people here today. Really appreciate all the interest in this topic and hope this will be a good resource for everyone with some ideas that you can use in your cases going forward. So just to kind of introduce what we'll be talking about today, as many of you are aware, there have been a few really awful recent AG and BIA decisions that have put up barriers to family and gender-based asylum claims. And a lot of these decisions also reference prior decisions from the previous Trump administration. And so we want to walk through today what these new decisions are, but also review the maze of these other decisions that are referenced, some of which had previously been vacated or overruled and are now back. And for a lot of practitioners, me included, maybe had not been practicing during the previous Trump administration. So it's helpful to review these things and also to just see how everything fits together, and go over some not only details of these decisions, but talk about some next steps and information that people can use going forward. And we also want to hear from you all about some of your experiences that you've been seeing on the ground so far. I want to just also give the caveat, every circuit is a little bit different. So we're going to make some general statements about the BIA decisions or the state of the law, but every circuit is different, and there may be circuits where some of those things have been challenged, the decisions themselves, or there had previously been good case law, and some of that is just outside of the scope of this roundtable. So I encourage you all to look at your own circuits and see what the state of the law is there. And I also just want to, at the outset, introduce our special guest who will be also presenting with me today, Ann Peterson, who has been senior counsel with CGRS, Center for Gender and Refugee Studies, and has litigated a lot of amazing cases, including one that we'll be talking about today. Yeah, and if you want to just say anything at the very outset, and then
Hi, I'm Ann Peterson. I use she, her pronouns. I am senior counsel at the Center for Gender and Refugee Studies, or CGRS. And I'm just very happy to be with y'all today in community in what is really a tough time, trying to make sense of all of these inconsistent decisions and hopefully setting us all up for successful challenges in partnership with Dina and Peter. So I will leave it at that and let Peter introduce us to these concepts.
thanks, Sam. Okay, so first I want to just briefly go over what is a PSG, a particular social group, and we still kind of rely on this seminal decision in matter of Acosta 40 years ago, where the Board of Immigration Appeals had defined this as a common or immutable characteristic, and they specifically mentioned sex and kinship ties as those types of characteristics. And it's something that people either cannot change or shouldn't be required to change. It's fundamental to their identities. And over time, that definition has evolved a bit. There have been new requirements added, and while this is a bit different in various circuits, some may not exactly use this three-part framework as defined here. Generally, in most circuits since 2014, this has been the definition in place. So, and it's three parts: the immutability definition presented in Acosta, as well as these two other requirements of particularity, which means is the group discrete? Are the boundaries clear about who's in the group and who's out? Are there benchmarks for how to define that? And then social distinction, which looks at how do people in the society view the group? Is it somehow viewed within the society as distinct or set apart from other people? And a lot of commentators have noted that the particularity and social distinction definitions are kind of overlapping, and even the board has conceded that. So there have been issues in practice with teasing these things out separately. But this is the definition that has been in place in most circuits for the past 10 years or so. And it also gets confused with the nexus requirement, which we will turn to on the next slide. And so, as many of you are aware, you not only need to present a PSG or other protected ground if you're seeking asylum, but you also have to show how the persecution has or would occur on account of that ground. And so that can also be a challenge where even if people have a PSG that is valid in practice, then it is hard to show the connection between the persecution and that ground. That being said, there is a lot of BIA and circuit case law that has for decades recognized PSGs based on both family ties and gender. So looking at, for example, 20 years ago, there were these two cases in 1996 from the board that looked at various groups based on each of those things. So matter of H, there was a Somali clan where people shared kinship ties and linguistic commonalities, and that was recognized as a PSG. And then this really important case, matter of Kasinga, that had looked at a PSG based on gender of people who opposed female genital mutilation. And there were other various cases in the years after that that recognized PSGs about these, based on these kind of general family or gender-based grounds. And then sometimes there were disputes about whether, for example, that would include extended family members, or was it nuclear family only? But the actual basis of these PSGs as being recognized through family or gender was pretty clear for a long time. And we had this language even in 2006 from the board saying that characteristics like sex and family relationships are easily recognizable and understood by others to constitute PSGs. So I think that reflected that even the board itself, on a general level, recognized that these were things that could give ground to PSGs. There were just some issues in practice with how to always flesh that out. And next slide, please. And that brings us to the LEA line of cases, which started in the first Trump administration. And this involved a man from Mexico whose family had owned a store. And there was a gang that extorted the family because they wanted to sell drugs there, and they threatened the man and his family members. So he sought asylum in the US based on a PSG of members of his father's family. And this case went up to the board, which issued this precedential decision where they recognized that the PSG based on his father's family was cognizable, but then still denied the claim based on nexus. And so most of the LEA decision, the first one is about nexus. And they introduced these requirements saying that essentially people have to show that family ties, if they are the protected ground, are the central reason for harm. So we refer to this as a but-for cause, because otherwise, if people don't have this reason for harm, but for that, and there's no other way to show a protected ground, then the claim would fail, and that the family-based reason is not just incidental to some other reason for harm, like a private dispute about land or business extortion or something like that. So it essentially added more requirements for people with family-based PSGs in seeking asylum relative to other reasons, perhaps. And there was also dicta in this decision that was very problematic about what we call the double nexus requirement, which essentially said that if somebody is seeking asylum based on family-based grounds, then there has to be some other reason that that persecutor is harming the family, such as the group has a problem with the family's religion or political views, which are other protected grounds under the INA, not just the family status itself. So this also imposed a higher burden. And then there was also dicta suggesting the imposition of an animus requirement, where people have to show that the persecutor has some kind of animus or specific anger directed at the family that kind of goes beyond what normally would be required to be shown for persecution. So this decision was in place for 2 years before Attorney General Barr issued this decision in 2019 that we refer to as LEA-2. And that overruled the PSG portion of LEA-1, but not the portion about nexus, so that remained in place. And so most of this decision is about the PSG analysis. It's pretty lengthy, but essentially, he looked at how the average family, like the average nuclear family in a country, would not be able to meet the social distinction requirement because it somehow is not well known within the society. So distinguishing perhaps a very well-known family within a society, someone who, you know, maybe their family are politicians or in some very high-profile position that they might be able to, but if a family just owns a business or something, saying that, well, they're not distinct within the society. And the primary justification for this was floodgates concerns that otherwise it's opening this expansive new understanding of particular social groups that otherwise isn't supported by the INA. And this was a really radical departure, not only from board precedent, but from what many circuits at that point had recognized as a basis for PSG. Most circuits had case law at this point saying that family could be a reason for people to show protected grounds for asylum through PSGs. There was also dicta questioning family-based PSGs that were not necessarily defined just by a nuclear family itself, but family-based PSGs defined by shared characteristics, such as, for example, family members of prosecution witnesses or family members who opposed a gang, saying that these were not particular enough because it wasn't clear what those qualifying characteristics meant, and that it was circular to the harm being presented. So this decision caused a lot of issues and was challenged in various circuits individually, and some courts pushed back. But then when we got to the Biden administration, the Attorney General, then A.G. Garland, vacated LEA 2, not LEA 1. He left LEA 1 intact, but vacated LEA 2 and alluded to a rulemaking on particular social groups, which then never happened. So LEA 1, LEA 2 has not been in place for the past 4 years, but has recently been introduced, as we will talk about in a moment. At the next slide, please. So last month, AG Bondi issued this new decision, matter of RERM and JDRM, that overruled LEA 3 and reinstated LEA 2. And so what this did essentially was restore the status quo that we had during the Trump administration of LEA 2, restricting family-based PSGs. And in this decision, she didn't really say very much substantively. It's only 3 or 4 pages, but it talks about that particularity and social distinction really don't square up with family-based PSGs. And she also talked about how the Supreme Court's recent Loper-Bright framework for statutory interpretation meant that the analysis from LEA 2 was, in her opinion, the best reading of the law about what a particular social group is. She also rejected the idea that most circuits have put forth that there is a categorical rule saying that nuclear family-based PSGs are cognizable, that they should be recognized as PSGs. And she said, oh, that's not consistent with what the asylum statute or BIA precedent says. And then finally, she criticized the Biden administration for saying in LEA 3 that they would have this rulemaking process on particular social groups, but that they never actually did so in practice. But then also said that she thought that case-by-case adjudication was the proper way for these things to be decided, and that a rulemaking would have been inappropriate. So this has been in place now for the past month and is essentially reimposing this framework from several years ago, but we think will be applied in much more aggressive ways even than had been in the previous administration. And this also brings us to another decision that had been in place put in place a couple of years ago, but now has been challenged in this 10th Circuit case, and we think will be applied in some circuits outside of that. And I want to pass this on to Anne to talk about, because she was part of the team challenging this case at the 10th Circuit.
Thank you so much, Peter. Yes, so for just a brief overview of the case, this case, matter of MRMS, involved a family whose son was killed by a cartel, and then the family was threatened by the cartel to leave their land. The cartel continued pursuing and threatening them even after they had abandoned the land, and constantly reminded them that their family member had been murdered and that they were coming for others in the family. So the board decided that the cartel solely targeted the family so that they could get control of the land. And then it stated a categorical rule that if a family is targeted as a means to an unprotected end, like obtaining their land or extortion, then the family membership is categorically not a central reason for the harm. And so that rule clearly violates the required mixed motive standard, the standard, the at least one central reason standard that's required by the Real ID Act. And then the board further said that an applicant must prove a desire to overcome the protected characteristic, or really it was like stated as an animus requirement. So animus against the family or a desire to overcome the protected characteristic. And additionally, the board reiterated LEA 1's dual nexus framework that Peter just went over, stating that an applicant may show nexus if, in addition to the family relationship, they can show the motive is intertwined with another protected ground. Myself and my colleague Ann Dutton, who argued the case, and our amazing colleague Vicki Nielsen at NIPNLG took up the family's case and filed a direct challenge to the BIA's decision in the 10th Circuit. And in August, the court vacated the board's categorical if-then rule as at odds with the Real ID, at least one central reason, mixed motive standard. They found it unlawful and because it prematurely ends the inquiry as soon as the unprotected motive is detected. And so they reiterated the standard that protected and unprotected reasons can coexist, and that the protected reason needs to be just at least one of the central reasons, and there can be multiple central reasons, right? So, as to the means to an end language, the court did find that it was okay because it could be read as consistent with the nexus standard established in matter of JBN and SN, but it did state that it did not categorically approve this framing because the means and end rubric could be used in a way that circumvents the mixed motives requirement. So it really did reiterate that mixed motives were required. And it also said that the double nexus standard that the protected goal must be tied to a protected ground, such as going after a family member to silence his father's political voice, could prove nexus, but it's not necessarily required. And then it suggested that amicus is required, but that it has a much broader meaning than literal animosity or ill will, which is consistent with some other case law. So the 10th Circuit stated that it's a broad concept that could mean a desire to overcome a protected characteristic, even with benevolent intent, or it could be something else. But the court did not decline to really address all of the ways that animus could be shown. So there is some wiggle room for advocates there. Now, what does the vacatur mean? Arguably, it means that it's vacated in all circuits because the language is pretty strong on vacatur. It states that this is unlawful. It's at odds with the statute. And also the board relied on 10th Circuit law to support its reasoning. And then the 10th Circuit found that the rule is contrary to law. It's arguably vacated in all circuits. We do anticipate that the board will probably keep applying it and outside of the 10th Circuit. But I would also note that MRMS has been rejected in whole or in part by the First, Third, and Sixth Circuits. And by its own admission is also at odds with the Fourth Circuit's nexus test. So I would point folks to, I don't know if y'all read Jeff Chase, former immigration judge, Jeff Chase blog, but he just did a piece on this that's pretty helpful. So I would encourage people to check that out. And on to the next slide.
Thanks. And yeah, we have a link to his blog to another article in the resources at the end. So yeah, I encourage people to read that. But yeah, thanks, Anne. And I want to turn to another nexus related decision that came out earlier this summer from the BIA. And as you can see, there are these kind of simultaneous attempts to restrict PSGs, but also to restrict nexus and just make it harder on both of those grounds for people to win relief. So this was a decision that came out earlier this summer from the board that involved a Honduran family where multiple male family members had been murdered, and the woman from this family that was seeking asylum presented a PSG of family relationships with her mother because all the murdered family members were related to her mother. And so the board denied this claim and focused on a showing that people must demonstrate that there is greater indicia of persecutory motive. Even though multiple family members had been murdered, the board determined that this was speculative and that it was an unfortunate coincidence or solely stemmed from statistical likelihood. Even though I don't think, yeah, most people statistically have not had family members murdered. It's really absurd on its face that they even suggested something like this. But this was the language that was presented, and they also said that applicants have to show some kind of proof of the persecutor's identity, their motive, even if multiple family members have been killed. They conceded that under the Fourth Circuit case law that applied, that you don't need to have explicit statements from the persecutors. There's a Fourth Circuit decision that says it's not reasonable to expect people harming someone to leave a note explaining all of the reasons why they're going to do this, but I think that the actual language that the board imposed here comes close to establishing a requirement like that in practice. And another troubling part of this decision that I think was absurd, they said that because it was a female applicant in this case, but only her male family members had been murdered, that she couldn't show nexus to a family-based PSG. And we're going to talk about gender-based claims in a moment, but I think you'll understand then how absurd that is when squared with what the board is also saying about gender-based claims. So I think this decision was clearly at odds with binding Fourth Circuit precedent, but it got remanded to the IJ. So any kind of direct appeal to the Fourth Circuit has now been delayed because of that. And this is another tactic that we're seeing the board do to delay these kinds of challenges that might not succeed at the circuit level, or that might succeed otherwise at the circuit level, so that this precedent will be in place in the meantime. Next slide, please. So this is a chart that I created. I'm a visual learner. I like to see things kind of mapped out, and I know it's confusing seeing all these decisions that reinstate, a previous decision or vacate one. So we created this and another one for gender-based claims that I hope will be helpful for you all. And you can maybe print and have at your desk if you're trying to make sense of all these decisions. Next slide, please. So with that, I want to turn now to gender-based PSGs and the AB cases. So in 2014, during the Obama administration, there had been this really good BIA decision called Matter of ARCG that recognized a PSG based on married women in Guatemala who are unable to leave their relationships. Most of that decision focused on social distinction. It talked about the country conditions evidence showing really horrific domestic violence and the culture of machismo in Guatemala. Recognized that the PSG was cognizable on that basis. And also notably, the DHS in that case did not argue against particularity of the PSG, past persecution or nexus. It conceded all of those things. So really the only point that was at issue there was social distinction. And so that was in place for a few years. And then, unfortunately, during the first Trump administration, we had this horrible decision in matter of AB1 from Jeff Sessions. And this case involved a Salvadoran woman who had also undergone really horrific domestic violence from her ex-husband, and she had sought asylum in the US based on a PSG of Salvadoran women who are unable to leave their domestic relationships where they have children in common. It's a really long decision. It's more than 30 pages long, and a lot of the opinion is actually legal analysis responding to ARCG, attacking the reasoning of ARCG on social distinction, but also because of these DHS concessions in that case. And so AB1 really talks about, oh, if there had been these concessions, then the board didn't really analyze all of the facts of the case, which, is really ridiculous because I think very often even the board today will only look at one reason to deny a case. But yeah, that was what they said. So a lot of this decision focused on PSGs and also the unable and unwilling standard for asylum. So this case, essentially, the AG said that if there's a claim that involves domestic violence or gang violence by a private actor, that generally it will not be something that's eligible for asylum. And he justified this by criticizing PSGs that were defined by a vulnerability to private criminal activity as being too unclear, to not be particular because there's a circularity of the harm that's being alleged, as well as unclear boundaries because of these qualifying characteristics, and also said that generally society will not look at these PSGs as a distinct group, so they're not socially distinct. And also, this decision contained a lot of discussion about the unable and unwilling standard of the showing required of why a government has failed or will fail to protect someone from this private actor, and stated that that requirement entailed showing that either the government had condoned the private actions or was completely helpless to stop the private actor from harming an applicant. And there was also, and it used the specific language about complete helplessness that we hadn't really seen at the BIA level before. And then finally, on Nexus, there was a brief discussion about how if there had been private violence because of this personal relationship between a victim and a persecutor, then PSG membership might not be the central reason for the harm. Next slide, please. Okay, and then in the subsequent two AB cases, AB2 and AB3, in the closing week of the first Trump administration, there was a decision by the then acting AG Rosen that tried to respond to several Circuit Court of Appeals decisions that had challenged AB1 as imposing a new heightened requirement for unable and unwilling, that essentially in AB2, AG Rosen said, well, we didn't change the requirement. It's still unable and unwilling. We just clarified what that means. And he also said that unable and unwilling and complete helplessness mean the same thing. It's just a different way of articulating that. And he re-clarified that the definition of unable and unwilling meant that the state had breached its basic duty to protect citizens or otherwise had to have harmed them or condoned that harm. Also importantly, it adopted the Nexus standard from LEA1, the board decision from back in 2017, that had said that the PSG had to be a but-for cause of persecution or not incidental or tangential to another private reason for harm, such as extortion or a personal dispute. So you can really see here how these decisions all fit together as a puzzle. And then later that year, in 2021, there was another AG decision from AG Garland that vacated both AB1 and AB2 and reinstated ARCG. And it was not a long decision. It was also only 3 or 4 pages, but criticized AB1 and 2 for adopting this broad language, creating a presumption against asylum claims based on private conduct, and also discouraging this case-by-case adjudication by essentially imposing this general statement that most cases presenting these facts will not succeed. He also criticized the AG for imposing this framework without really seeking any public briefing or amicus briefing or input on this rule before adopting it. And also, as we talked about with the decision vacating LEA2, here the AG had promised that there would be a rulemaking process on unable and unwilling, on PSGs, on Nexus for gender-based claims, but this never happened throughout the 4 years that followed of the Biden administration. And that brought us to the latest decision on the next slide. In matter of, yes, this one, matter of SSFM. So this came out a month ago from AG Bondi, and this decision reversed what AG Garland had said in AB3. So it overruled AB3 and ARCG and then again reinstituted AB 1 and 2. And it's not a long decision, it's about 3 or 4 pages, but it basically defended the broad language in AB 1 that had created this presumption, because it said that there will be fewer far between of cases where there actually is a government failure to control private conduct that rises to the level required to win asylum. There's not a lot of substantive discussion in this decision. It's very short, and so primarily just returns to the status quo of AB 1 and 2. And as with the decision reimposing LEA 2, cited to Loper Bright, said this is the best reading of the text under the INA, and criticized the Biden administration for not only vacating AB 2 without putting forward a clear replacement, but also for saying that they would have a proposed rulemaking and then never doing that, while reiterating that case-by-case adjudication is the preferred way to proceed and not some kind of broad-based rule, despite the irony of imposing this broad language and saying that there should be this strong presumption. So yeah, do with that what you will, but I think the contradiction of that is very clear. Next slide, please. And with this, I want to pass it on to Anne to talk about another awful decision recently about gender-based PSGs that we saw.
Yeah, the hits just keep on coming. So this is a matter of KSG, which I'm sure everyone has heard of at this point. This case involved a Salvadoran woman fleeing gender-based violence who sought asylum based on several PSGs, including the group Salvadoran Women and the group Salvadoran Women Viewed as Property. This was on remand from the Sixth Circuit, so that the BIA could fully consider the PSGs. And then the BIA issued this decision in July. So there were two central holdings. The first holding held that a PSG defined solely by gender or gender and nationality is overbroad and insufficiently particular to be cognizable because it encompasses wide cross-section of society. Sometimes this reasoning is framed as too broad or amorphous. We've seen this a lot from the agency, and also from a handful of, slightly under a handful of courts of appeals. And this holding also explicitly extends to men too. The second holding was that the proffered group of Salvadoran women was not particular and that Salvadoran women viewed as property lacked particularity and social distinction. And both analyses were based in part on record evidence that women faced disproportionate levels of violence, and enacted legislation to protect women. So that was insufficient in the board's view. So as in matter of AB, here the Board of Immigration Appeals used sweeping language to make broad statements that generally victims of domestic violence would not be eligible for asylum. And like those cases, LEA 2 and others, the board electively cited several circuit court decisions and suggested that Congress in the Refugee Convention protocol did not identify sex as enumerated ground, and that by extension, that means it did not intend for it to be protected ground. Of course, that we've heard this said by Bill Barr in LEA 2 about the family-based group, and this so-called reasoning would kind of make the particular social group ground superfluous. So, but we're going to expect to keep seeing this kind of flawed reasoning. So a couple important notes about KESG. The BIA clarified that its reasoning does not extend to social groups that include additional characteristics beyond sex and gender. So for example, women from minority religion who have lived alone or widows. So there could be other articulations that narrow the group. Although we'll talk about later in several circuit courts have stated that size and breadth does not matter. And so this is definitely in conflict with those higher courts rulings. It also clarified that its reasoning does not affect cases involving female genital cutting, and stated that earlier case law that approved, so this is kind of incongruous, but stated that the earlier case law that approved gender-based groups in GC claims were irrelevant to other gender claims that don't involve FGC. So, for example, if you had previously been pointing to matter of Kasinga, as support for the board's longstanding recognition of gender-based groups, this case says no, 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 no. That case is irrelevant to supporting any precedent for these types of groups. Um, it's important to remember, as discouraging as this is, that this decision did not end gender-based asylum or the cognizability of gender-based social groups. The law of the circuit controls. And while the circuits are splitting on the size and breadth issue, advocates can still argue for other protected grounds and case-by-case adjudication, et cetera. And we'll talk more about that later. And next slide, please.
Thanks, Sam. So this is another chart that I hope will be helpful for you all, kind of summarizing. It's a bit of a simplification, but I think it's helpful to just see how these decisions had impacted, and when you're responding to one of these, you can know what exactly you're citing to, or what the government is citing to. Great. Next slide, please. Yes. So I wanted to talk here about some of the problems that we've seen across all of these decisions, common issues, and then some ways that you all as advocates can respond to these in your work. Yeah, and also please feel free to jump in here as we're talking about this. But yeah, first, I think one of the obvious issues with this that I see is the ping pong legal framework of these decisions being in place and then being vacated and then coming back, and it creates a lot of chaos. I call this zombie precedent because something like AB2, it was essentially vacant for 4 years, and now it's back again, even though it's a decision that is many years old. AB1 is 7 years old now, and hadn't been in place for more than half of that time, but is back. So it leads to a lot of issues for advocates. I think one way to kind of combat that is to rely on the stability of many circuits have very long-standing helpful precedent that is binding on immigration courts and BIA cases in those circuits, recognizing family-based or gender-based PSGs that preceded these new decisions, and sometimes even explicitly rejected those decisions. And because Chevron has been tossed out, there's no more Brand X deference either. So basically, the agency cannot issue a new decision rejecting a circuit court precedent that is prior, but is disagreeing with that agency decision. They have to defer to what the circuit court has said previously. So I think that's something that yeah, you all have to look at the circuits you're practicing in, but as a way to address this.
I think that's right. And then also, the board's own precedent says that it has to follow the law of the circuit in which it sits, or in which the case arises. And so I think, it's useful to remind the board of that. Yeah, so Joanna says, what can we explain why they can no longer use Brand X? Brand X, there's some dispute about that. So I think that some of the agency would sometimes say they can. Um, but because Brand X was an extension of Chevron, I do think that there's a strong argument that Brand X no longer applies. They might seek to use Skidmore deference, but or they might just say that they're bound, but at least it's worth preserving the arguments that they are bound by the circuit court, and that they um, that they have to follow the law of the circuit. Um, yeah, how to leverage. We're going to talk about that in a little bit.
Yeah, we'll get there. Even on this side, actually, briefly, but yeah, that's true, and I think that Gorsuch in particular really hates Brand X deference even more than he hated Chevron deference. So perhaps there will be another Supreme Court case at some point explicitly overruling that. But as you can all imagine, because there's all of these cases being vacated and then coming back, and as many of you all are well aware, some of these cases drag on for many years. waiting for merits hearing or on appeal. I've had non-detained cases that I'm working on at the BIA that have been pending for 2 or 3 years, fully briefed. And the law in some of those cases has changed multiple times, now has changed again. And so we've had to submit supplemental briefing. So I encourage you, if you have a case that you're waiting for a decision from the IJ or the BIA, to submit supplemental briefing. We have some template briefing on AB2 and LEA 2 that you can use in your cases. It is somewhat Fourth Circuit centric, but can be adapted, that we'll send out after this. So yeah, I encourage you to challenge the parts of those decisions that aren't applicable in your circuits through supplemental briefing. And then one thing also on a practical level, because some of these decisions are just being vacated by incoming administration, or they get remanded, it makes it harder to challenge them directly in circuit courts. So one way to deal with this is to, besides like leveraging the prior precedent in those circuits that was hostile to those decisions, to look at how under Loper Bright, the positions being presented in these cases is not the best reading of the statute. And in doing that, we encourage you to coordinate with people who do appellate litigation, people at organizations like Amica or CGRS, so that there's kind of a common front on how to challenge that precedent while it's still live. And then it can't just be revived later in 4 years if there's a new administration. Next slide, please. Okay, and then another issue, as you can see, sometimes these PSGs are rejected because they're too broad. Nationality plus sex is rejected as not being particular enough, but then if there's a PSG that is too narrow, then like nuclear families, then it's seen as not being social distinct and therefore also not cognizable. So this is really an impossible tightrope that the board and the AG expect people to walk sometimes. So I think, unfortunately, a way to respond to this is to just try to cover all of your bases and present PSGs that cover both of these formulations of narrow, but also more broad in how you respond to these challenges. And maybe you don't need 10 or 15 PSGs, but I think it would be good to have at least a few that are more narrow and also broader in your cases.
And also raise other protected grounds that are supported by the facts.
Yeah,
Sometimes it's an easier path for an adjudicator to grant on political opinion, for example.
exactly. Yeah, so you need to look at the facts of your own case, but yeah, if there are other grounds besides PSGs, rely on those as well. And then this kind of brings us to another quandary from these decisions, which is that the analyses for PSGs often conflate social distinction and particularity, and they also confuse the PSG analysis with the nexus analysis. And it ends up kind of collapsing these requirements into one kind of soup of requirements where the board finds any reason to deny. So I think a way to combat that is to really focus very clearly in your briefs on all of the elements of the asylum claim, the various prongs of the PSGs that you're proposing, and have very clear evidence of nexus that you're presenting so that these things on your end are being shown very discreetly as the individual legal tests that they are and should be. And then finally, we've seen this language in the BIA-AG decision saying that, oh, there has to be case-by-case adjudication. You can't have categorical rules recognizing nuclear-based family PSGs or gender-based PSGs. But at the same time, they're imposing these decisions saying generally these groups won't be cognizable, or generally people can't show nexus in these situations. So I think you need to really emphasize the language in these decisions about how case-by-case adjudication is important. And a lot of that will boil down to, if you have really strong evidence, just highlighting that as much as you can, and reiterating that the board and the IJs cannot just impose this categorical rule. They have to look at every case on its own merits.
Peter, just wanted to lift up
Yeah.
quickly some what you said on Nexus. During the first administration, when we were working to challenge AB, we were really looking for cases where there were facts in the declaration, for example, saying in specific phrases what the persecutor said to the client. So, for example, one of our cases, there was a line where he had told her, like, you're my woman. So just getting anything super specific like that can really give a fighting chance on the Nexus claim.
Yeah, that makes sense. And I think that addresses some of what we talked about with the new Nexus decisions. If you need evidence of motives, like, yeah, it's really good to have words like that that people actually said. We
Yeah,
wanted
and
to
if you're unlucky enough to get a factual situation where that didn't happen, where it wasn't so clear, just really it's, contextualizing and building up all of the circumstantial evidence and reminding the tribunal, wherever you are, that, the Elias or Zacharias test is both direct and circumstantial evidence. So circumstantial evidence alone can prove these cases.
Yeah, that is super important. So a few other questions for discussion. We'd love to hear from some of you all as practitioners on the ground. If you've been seeing any IJs or the BIA already apply these new decisions on the ground in cases that you all have worked on. I know, yeah, we have some BIA appeals that are pending and have been for a while, but where we expect them to apply these. But yeah, has anyone who's with us today already seen this happening in any of their cases? Feel free to, yeah, chime in the chat, and I don't know if you all at CGRS have seen any of these things yet.
We've seen a few. We also do have on our outcomes tracking now, we do have a place to tick off certain cases if they're being applied. Um, I know that we just filed an amicus in a Sixth Circuit case that involves KESG. Um, and we've filed supplemental briefs in some of our board cases that are pending. So actually those we filed a sub brief on KESG and another sub brief on SSFM, so the ABs, and those are actually redacted and available on our technical assistance library if anybody wants to take a look. Generally, we're arguing that those do not apply because they're not categorical rules, and it's case by case adjudication, etc. But feel free to make use of those. And also, please do report outcomes to us so that we can better track these cases and be responsive. We did see this happen last time, though. So last time around with the ABs, we did see even where maybe the cognizability of a social group wasn't addressed by the IJ, maybe it was presumed the BIA would nevertheless apply AB to say that the PhD wasn't cognizable and wash their hands of it. And then, so a lot of those cases did end up going up. And then because I think the government didn't really want precedent, like adverse precedent, oftentimes they would make an offer of remand. So it's a little dicey in the strategic choice making about what challenges to take.
Yeah, and I think that kind of leads in well next. Cindy, to your question, there's a link to these sample to the TIA library that Anne mentioned in the resources slide that we'll send out later, and also sample briefing from Amika that we will send out in an email as well later today. But yeah, that brings us to the next question about this, which is how are some of the things that we went through during the first Trump administration relevant now? What lessons we have from that, and what's different this time around, maybe?
Yeah, so I think that we did have a lot of success, not just, I'm not speaking about CTRS, but I'm speaking about as a community, as immigration litigators in this asylum space. Um, Last time around with, ch really challenging AB one in particular. And we are dealing with kind of a better playing field of case law in a lot of circuits. In some circuits, less so. So they weren't all winners. But so I would say kind of the strategy is not that dissimilar this time around, pushing for case by case adjudication, pushing back on general rules, building the record, arguing for other protected grounds. And then, as I said, like many good precedents did come out in the AB fights, recognizing gender-based groups, or recognizing there's no general rule. So I'm thinking about the first, second, fourth, eighth, ninth, and then the Seventh Circuit obviously doesn't apply the three-part test. So
Yeah,
kudos to anybody there. Um, and then, you know, the law of the circuit controls. I'm seeing this note from Maria Clara, um, that her client was denied in Virginia based on KESG, and it
mm,
always blows my mind how cases in the Fourth Circuit that has such great law on asylum, the adjudicators at the agency level just blow it. I just argued a case there last month, that was baffling how much the agency just ignored the controlling law. So I mean, I think the
yeah,
best you can do is make your record and build your arguments and preserve all of your arguments, because there's a good chance if you're there that you might be going to the board and then the Fourth Circuit Court of Appeals. And please
yeah,
get in contact with us. No good news from the Fifth Circuit. I'm sorry, Hiroko. Um, it is not great. I mean, it's the law on particularity in the Fifth Circuit, Third Circuit, and Tenth Circuit says that sex alone is insufficiently distinct. And the 11th Circuit has kind of a similar but not exactly the same determination, that says immutability of sex alone is insufficient. So that's a slightly different and slightly more nuanced determination. But as I said, please coordinate with experts on these issues, coordinate with litigators, reach out to us, reach out to Amica, if you're planning on bringing these cases up to the Courts of Appeals, or if you need technical assistance while you're litigating before the IJ or the BIA, so that we can continue these fights together.
yeah. No, I think that's really important. And yeah, Maria, definitely, yeah. And if you're thinking about appealing, yeah, feel free to reach out to us. And it sounds like they really flouted Fourth Circuit case law on that decision. It's really frustrating. Yeah, if we could turn to the final slide. And we talked about the last question, but yeah, just wanted to really briefly touch on Loper Bright and the end of Chevron and how maybe that impacts some of these challenges. I know that I think personally that a lot of people were more optimistic about the sea change that this would bring than what we've been seeing in practice. But I think that as the board starts to go overboard a bit, that the courts will feel a bit more licensed to reject some of these kind of absurd interpretations of the statute, and will be more willing, hopefully, to rein in some of the excesses of what is happening because of Loper Bright. But I don't know that it will be reinventing everything from square one, like saying, oh, we'll go back to Acosta as the PSG definition because of Loper Bright, which I think some people have thought earlier might happen. But yeah, Anne, what are your kind of takeaways on this?
Um, yeah, I mean, I think that uh, as I said before, the board is is bound to apply the law of the circuit, but the board and IJs often ignore that binding reality. Um, So, there's some different possibilities, here as far as the analysis goes. If the circuit has already agreed with the board's holding or underlying principle, then the agency law will apply. I think it's just kind of important to understand how this works. If the circuit is silent on the issue, then the agency law will apply until it's challenged at the Court of Appeals. And then if the circuit has rejected or limited the holding or underlying principle, then the circuit law should control. But as just as I said before, the key word there is should, because adjudicators are, IJs are going to IJ and board members are going to board member. So as far as, I think that you can say to the agency that they have to apply the law of the circuit and that controls. If you're in a circuit that does not have great law, you can argue around it. You can distinguish cases. You can argue for case by case analysis. You can raise other grounds. There are workarounds, right? Um, but I think that there are going to be challenges under Loper Bright. I think that we need to be very cautious about where and which vehicles we choose for those challenges, because not all cases are created equal for the purposes of trying to return, for example, back to the Acosta um, social distinct or the Acosta PSG cognizability test, which is I think where we all want to go. But there are definitely courts that won't be amenable, and we don't want them leading the pack. And as I said, like not all cases are going to be ideal vehicles. That being said, we are going to want to take these cases because we're going to be other spaces are also going to be dealing with Loper Bright in their own space and setting precedent that may affect where we come out. So,
Yeah. To your question, Sylvia, I'm not aware of any. I know that I've been following these BIA precedent decisions and other cases we've heard about from colleagues about IJs pre-termitting otherwise probably viable claims, especially relying on this new precedent. So I think that that will reach a circuit level at some point soon. It just hasn't percolated up yet, but that's the kind of thing where we would definitely encourage you to reach out to us or other similar orgs to coordinate those challenges so that it can be done on a unified front, because it is, yeah, really troubling that people don't have those facts at all. Yeah, I want to be respectful of people's time. I know this is a lot of material to pack into an hour, so we've tried to be as concise as possible, but here are some additional resources that you can turn to, including the TA library that Anne had mentioned that has a lot of great resources, and some other more recent practice advisories and resources, as well as things from the prior Trump administration that are now relevant again because those decisions are unfortunately back at the agency level to some extent, circuit specific. But yeah, I encourage you to check all of these resources out, and we will send out the slides later as well as some sample briefing that hopefully you all can adapt to your cases. It is kind of fourth circuit specific because that's where we do a lot of our work, but can be adapted to the circuits that you all are practicing in as needed.
and I'll just say we are going to we're working on updating our advisories on the LEAs and the ABs, and also we have one on KASG that needs to be updated post SSFM. And we are working up bench memos on these cases so that people can, have the state of the law as they're drafting briefs. And please reach out to us for TA.
Thank you so much, Anne and Peter. You did an amazing job. Seeing a lot of appreciation in the chat. As Jacob Lichtenbaum said, you did a very good job of telling this sordid tale. So thank you for getting everyone up to speed on the history of this and sharing some strategies. We really appreciate it. For anyone who missed in the chat, if you did not receive an email from us about this roundtable, please send an email to me at Adina, ADINA, at amicuscenter.org so you can add you to our list. We've recently shifted over how we're sending notices and resources through a new email organizationally. So we want to make sure everybody's on that so you can get the replay and the resources. Thank you so much. And I hope everyone has a wonderful rest of the day. Appreciate both of your expertise.
Thank you.
Thank you.
All right. Thanks, everyone. Take care.